Welcome to today's verdict. I'm your host and trial attorney, David Lesh. We have three distinct topics on today's show. First one, we're going to be discussing ACS and the illegal forcing of children to either disrobe or to investigate their parents. It's very important. Next up is going to be the wheelchair accessibility to New York City taxis. In 2014, there was supposed to be almost a given settlement, and taxis were supposed to have access to wheelchair accessibility, but hasn't worked out that way. We have an attorney on here who's going to be discussing it. And finally, those illegal cannabis shops down in the block that you see, well, somebody's been trying to put them out of business. And it's an assembly member who's going to be here to talk to you about it. So as you can see, we have much to get to. So stay tuned. Today's verdict starts right now. All right, welcome back to today's verdict. I'm your host and trial attorney, David Lesh. We have joining us today another David Shalleck Klein, the founder and executive director at the Family Justice Law Center. David, thanks for being with us today.
Thanks for having me.
All right, so this is basically a lawsuit against ACS, and it's for injunctive relief. Maybe you could just explain to the viewers a little bit about what that means, just injunctive relief to begin with.
Right. So this is a civil rights class action lawsuit against New York City for ACS, the Administration for Children's Services, having a policy and practice of routinely violating families' Fourth Amendment rights by using highly coercive tactics to enter and search their homes and strip search their children. And fundamentally, what the lawsuit is aiming to achieve is, as you said, David, injunctive relief. Which is just a legal way, really, of saying a change in ACS's policies and practices through the court process to get ACS through different training and supervision, through different field policies, through different data collection and publication and analysis and other things to fundamentally change the way they interact with families during their investigations.
I know you have a lead plaintiff. Gould is the lead plaintiff. Tell us a little bit about what happened to Miss Gould, if you could.
So Miss Ebony Gould is a Black mother, single mother, who's a survivor of domestic violence. She and 8 other parents are the named plaintiffs in this lawsuit, and Miss Gould is the first named plaintiff. So the case will be known as Gould v. the City of New York. Over the last, roughly 4 years or so, Ms. Gould has been subjected to at least 35 home searches by ACS that were all from anonymous reporters who were based on malicious and false calls from her ex-partner, her abuser. And her abuser has been weaponizing the child maltreatment hotline by making repeated false calls against her, accusing her of all types of, nonsense charges that had absolutely no veracity to them. And that is, of course, a problem in and of itself. But what happened next was that the ACS, the caseworkers, reacted to each of these anonymous calls with these high-handed, traumatic, and intrusive tactics to get into her home, to search her home top to bottom each time. I mean, over 35 times they searched her home, and frequently would strip search her children as well. And every single one of these allegations turned out to be completely baseless. And unfortunately, Ms. Gould's experience is not that uncommon. A Black child in New York City has a 50% chance of being subjected to one of these investigations by the time they turn 18. This is a widespread and rampant problem, and that is why, communities, public defender offices, children's rights organizations have all said the time is now for a civil rights action to stop these practices.
Now, there is some mandatory reporting, though, if that does have to take place, or should I say a mandatory investigation. But there are certain limits as to what that investigation should be. Am I correct?
That's absolutely right. There's both mandatory reporting, which means that if you work in a certain field, such as, a school teacher or nurse or anything else that really works with children, and you suspect child maltreatment, you have a requirement to make a call. But there's a difference between mandatory reporting and anonymous reporting. And frequently the reports that would come in against our plaintiffs were anonymous reports. But David, you're absolutely right that there is a requirement for ACS to investigate once there's been an allegation that's come in. And this case is not in any way saying that ACS should not investigate these reports. Rather, what it's saying is that they cannot violate the law in the course and in their conduct in these investigations. For a government agent like ACS to go into someone's home or strip search a child is a major thing, right? There's an ancient adage, every person's home is their castle. Of course, if there are emergency situations, they can go into a home without a court order or a parent's consent. They need to, another way they can get into a home is through a parent's consent. But the preferred way that a government agent comes into a person's home is through a court order, what's frequently known as a warrant. The problem is that ACS gets warrants in less than 0.5% of their investigations. And it's really actually much less than 0.5% of their investigations, because in each of home searches, because in each investigation, there are usually 4 or 5 home searches. So it's really, that's a conservative estimate. And what the lawsuit is saying is that if you're going to get a parent's so-called consent, you can't do it by threatening to take away their children. You can't do it by threatening to bring the police. You can't do it by misrepresenting the government's authority and stating that you don't need to get a warrant. You can't do it by making these big public scenes in hallways to embarrass parents and force your way in. So it's not saying that ACS can't get into homes. They can and they should, but they need to do it legally, and they can't do it through this regime of coerced acquiescence through fear and through these really traumatic tactics.
And have you had the class certified yet?
We just filed the complaint a week ago. We have not moved for class certification yet. That's down the line. And just one thing I really want to make clear that viewers understand is that these tactics that ACS is using when they go into homes and they force parents to act, subservient and acquiescence to them, and they look under beds and they read labels in medicine cabinets and they open drawers and they demand that children lift up their shirts and pull down their pants. And they force children to see their parents not being able to protect them in their own homes. This is really scary. It's terrifying. And 93% of these investigations do not lead to charges being filed in court. And many of the charges that are filed in court are ultimately dismissed. And ACS has approached this issue with a sort of no harm, no foul mentality. And what communities are saying is there is harm. These investigations and the tactics that they're using, where they strip search children, they humiliate parents, and they create such disturbances in family households, is harming the very children that the agency is tasked with protecting. And that's not okay. And there are certainly racial dynamics to it as well. The fact that predominantly and disproportionately, this is Black, Hispanic, and low-income communities. This is really the community coalescing, pushing back, and saying enough is enough, and we're fighting back.
What types of investigations would you be better off suited and be okay with? Not checking medications, not doing strips, shirts. What type of stuff?
I think fundamentally the problem is that ACS treats every investigation like every other investigation, that there's no tailoring. It's a very cookie cutter approach, that no matter what the allegation is, no matter what the veracity of it is, no matter any type of corroborating evidence, no matter that the family has already gone through 15 prior investigations, that in each one, they're treating it like every other one. And they're searching the homes in the same way. They're strip searching the children in the same way. They're using the coercive tactics in the same way. And what we're saying is that sometimes these types of searches are necessary in emergencies or when a judge says there's probable cause for it and it needs to be done in a tailored way. So the lawsuit's not about stopping the investigations themselves. It's about making sure that they're tailored, they're necessary, and they're complying with the Fourth Amendment.
Maybe you can come back and let us know how once the lawsuit is filed and where everything is before the court. Maybe you can let us know how it's going.
I'd love to.
All right. Thanks very much. Well, stay with us. Today's verdict has so much more coming up right after this.
Only 57% of New York City high school students are college ready by their senior year. "55% of high school graduates either have no plans to attend college or are uncertain that they will ever attend. "34% of young adults don't go to college because they can't afford it. Discover what's possible. BronxNet's education programs, internships, and opportunities help engage and inspire Bronx youth and beyond to pursue their passions. Be a part of the BronxNet family. Whether you're interested in our shows, joining a class, or donating to support our mission, visit BronxNet.org to learn more.
Okay, welcome back to today's verdict. I'm your host and trial attorney, David Lesh. We have with us today Damani Sims, associate with Shepard Mullen. Damani, how you doing today?
I'm really good, David. Thanks for having me here.
Tell us a little about you. What made you decide to go into the law?
Yeah, that's an interesting story because I originally wanted to be a doctor, and I took organic chemistry and realized, well, I need to find something else. So law was a natural alternative for me. So I started my legal career at the Brooklyn DA's office. I was a prosecutor for about 8.5 years, and then I clerked for a federal judge in the Eastern District of New York. And then from there came into private practice to do commercial litigation. So I've been doing this for about 7 years now, in this precinct of the law. And it's been interesting, it's been challenging, but it's been certainly rewarding, especially with cases like the one we're about to discuss.
Yes, let's talk about the wheelchair accessibility case, if we could. I know that yesterday you filed a motion, I believe, in federal court to compel the NYC Taxi Limousine Commission to comply with provisions. So tell us, maybe you could walk us through the history of the lawsuit.
Sure. So last week we filed a motion to enforce the settlement agreement. So this lawsuit was filed in 2011, and it essentially challenged the New York City Taxi and Limousine Commission to achieve an accessibility rate that was accessible for, or rather, an accessibility rate period that would benefit the disability community. At the time, 98% of the yellow medallion taxi fleet was inaccessible to wheelchair users, which even in 2011, by those standards, was completely unacceptable. So Shepard Mullen joined forces with disability rights advocates. We filed a lawsuit, and it went through several permutations. But at the end of the day, we were able to reach a settlement. And we reached that settlement in 2014, where the Taxi and Limousine Commission agreed to achieve a 50% accessibility rate. We wanted more. We wanted 100%, and we thought that was more reasonable, but we accepted the 50% settlement, and then we were off to the races. Now, during the course of the last 10 years, there were several stops and starts where the city was not meeting their requirements under the settlement agreement. And we gave them extensions. We gave them several extensions over the course of those 10 years to actually honor their obligations under the settlement agreement. And then, without warning us more recently, and this is what compelled us to file this motion to enforce the settlement agreement, they contacted us and said, you know what? We don't think we're going to meet this 50%, and we don't think we should have to. So let's think of another solution, which was completely unacceptable to us.
Well, why would they think they don't have to at that point when there was a settlement on the record that said that they do have to?
That's a great question, David. And I think their excuse was the economic realities of the transportation market in New York have changed. And they've changed to the extent that you have for-hire vehicles like Uber and Lyft that have now entered the market, and that's decreased the number of yellow medallion taxis that are available. Well, if that were the case, if the reduction in the number of yellow taxis were really a thing here and the fleet was reduced in New York, then that would actually make your obligation a lot easier to meet because there are less taxis that are on the road. They did not see it that way. And we elected to take, I don't even think this is an aggressive approach, but we think it's the right approach because we've been waiting for over 10 years for them to honor their obligation. And we have been more than solicitous in our extensions to them. So enough is enough.
I'm wondering what a federal judge can think when you have 10 years to comply with a direct order, and you then say, well, I don't think we can, and I don't think we should. I'm just wondering how that's going to play out in federal court. Probably not too well.
I think you're right, David. I don't think it's going to play out well at all, especially in front of the same judge who signed and entered the settlement agreement. We believe he's going to be none too pleased with the approach of the city on this. And one of the reasons is he heralded the settlement agreement as something that was long overdue and a civil rights victory. So I think against that backdrop, the city and the Taxi and Limousine Commission are going to be hard pressed to come up with legitimate legal reasons and arguments to show why they should not have to honor the terms of the settlement agreement.
Now, what is it? What is the reason? Is it because the cars are not equipped and need to be expanded? I mean, there are different types of taxis. Well, there are the smaller taxis, bigger taxis. What seems to be the holdup here?
Well, I think the holdup, according to the city, according to the TLC, their holdup is they can't compel people to purchase these medallions. And if the medallions are going to be connected to wheelchair accessible vehicles, they can't compel prospective taxi drivers to buy those particular medallions, which is a bit ridiculous because if you are creating a fleet that's going to be equitable for the disability community, and if it's a 50% wheelchair accessibility rate, then there really isn't any reason why enough of those prospective taxi drivers or medallion purchasers can't purchase a vehicle that is equipped to service someone that is using a wheelchair. We haven't received, the real answer is we haven't heard any legitimate basis, any legitimate reasons for the TLC not to honor their obligation. We don't buy the economic argument. We just don't. It's actually such a flawed argument that it helps our case. Yeah. And it helps our argument that they should be servicing this community more than they are. And again, we stress, we've been more than solicitous, even in the 50% rate, because we think it should be much more.
Well, we're going to have to leave it there. We don't have too much time, Damani. I want to appreciate it. Appreciate you coming on. When do you think this will get before the federal court and we might actually have some kind of argument or eventually a decision? When do you think?
We would say today is March, or rather February 27th. We would think likely the end of March after the motion to enforce is fully briefed. We think the court likely will set a date for oral argument if they don't want to decide on the papers. Set a date for oral argument, likely at the end of next month.
Well, hopefully you'll come back and you'll let us know what the decision is. We're curious.
I'd be happy to.
All right, well, thanks. All right, stay with us. Today's verdict has so much more coming up right after this.
Hey everyone, it's your girl Kat from the Kitty Rose Lifestyle, also from The Next Chapter, where we discuss shades of gray every week right here at BronxNet, Saturdays at 11 p.m. Wow, 30 years. 30 years of BronxNet public access television. I'm a girl from Brooklyn and came to the Bronx 25 years ago, started my journey on BronxNet on public access television in 2016, and BronxNet is where I got my start. BronxNet, I feel like, is a home away from home. They support all of my endeavors, and I wouldn't have been able to be on any of the other channels if it wasn't for the fundamentals that I learned right here at my start here at BronxNet. So I am so appreciative. My son says I should stop telling people I'm from Brooklyn because I've been here now, Bronx Strong, for 22 years. So I'm so grateful, and I wish you much success in 30 years, 30, 30, 30, 30, 30, 30, 30, 30 more, because public access is necessary so that people like myself can have a voice. Yes, BronxNet, it's your girl Kat from Kitty Rose. Check me out every Saturday at 11 p.m. right here, Channel 68, The Next Chapter, where we discuss shades of gray. Mwah.
Okay, welcome back to today's verdict. I'm your host and trial attorney, David Lesh. We have joining us today, Assembly Member Jennifer Rajkumar. How are you doing, How are you doing today, Assembly Member?
I'm doing great. Thanks for having me.
It's a pleasure. First of all, tell us a little bit about you. You haven't been on the show before. What made you decide to become an Assembly Member?
Well, I'm State Assemblywoman Jennifer Rajkumar, and in 2020, I ran against an 11-year incumbent, and people told me, Jennifer, you're a nice girl, but you have no shot. But I won, and I won by the largest margin of any challenger in the entire state. And I just feel so grateful to be an Assembly Member, especially as the first Indian woman to ever be elected to New York State office. My mom was born in a mud hut. My parents came to this country with $300 in a suitcase. And now I get to serve as the first Indian woman ever elected in New York State. So I'm grateful every day. And only in New York could this even be possible.
That's wonderful. Let's talk a little bit about this illegal cannabis peddling. How widespread is it?
Very widespread. So currently there are 36,000 illegal smoke shops in New York State and only about 60 legal ones. That means there's 1,000 times more illegal shops than legal ones. It's such a crazy situation that many New Yorkers wonder if they're high. I mean, how did we get to this point?
Well, I walk down 161st Street, by the concourse over here, and I see a lot of different shops. I don't know what's legal. I don't know what's not legal. How do you tell?
Well, most of the shops are actually illegal, which I think many New Yorkers don't realize. Only about 60 cannabis dispensaries in the whole state have been licensed, and the rest are all illegal. So this is a real problem, and that's exactly why I introduced the Smoke Out Act in Albany, which will close down all the illegal shops and get it done this year.
Well, how does the bill, empower the municipalities in addressing the issue of illicit cannabis? What is it? What kind of powers do you give them?
The Smoke Out bill solves a problem in the existing law. Currently, only the State Cannabis Control Board has the power to shut down illegal shops. But the State Cannabis Board simply doesn't have the manpower to get the job done. But guess who has the manpower? The city of New York and all the municipalities around the state. So the Smoke Out Act gives the authority back to the city and the municipalities to shut down these stores. That way the city doesn't have to wait for permission from the state before acting.
What about access to the legal shops? How do we balance that to make sure that we're not treading too heavily on their rights as well?
To give these legal stores a fair shake, we need to shut down the illegal stores, because the illegal stores are killing the business of the legal stores. And the people who are operating legally, they worked very hard and went through a long process to get their licenses. So the current state of affairs is really unfair. And on the bright side, Mayor Eric Adams said that if the Smokeout Act passes, he will be able to shut down all the illegal shops in New York City within 30 days. So we have a real solution here that's going to help the legal dispensaries as well.
How does this bill align with the federal and the state laws regarding cannabis regulation? I mean, you have laws on the books. How do we equate the both of them?
Well, in 2021, the legislature legalized marijuana.
Right.
That was a sea change. But there are parts of the law that need tweaking. And that's what the Smokeout Act bill does. The Smokeout Act is an act that everybody agrees with. I mean, I have not met one person, not one, who wants the illegal shops to stay open. This is a unifying issue across our entire state and across our entire city. So now we just need bold action and clear thinking to get this done.
What else have you been working on in your district? What other things have you had coming up?
I've also been working on e-bikes. So e-bikes have been causing a record number of deaths in the city and a record number of fires from the lithium-ion batteries that are very dangerous. In fact, just last week, there was a terrible fire in Harlem that injured 18 people. And that was because of a lithium-ion battery. So I introduced a legislative package to regulate e-bikes. And what it does is it empowers the state DMV to give e-bikes license plates and to make sure they are subject to insurance and inspection. That way, e-bikes are going to become safe and we will prevent these terrible accidents.
Well, we really appreciate the job you've been doing there. I know it's been hectic and you've been very, very busy since getting into office, and congratulations. Hopefully you can come back and let us know what's been going on with the illegal cannabis and the e-bikes.
I'll love to. In 5.5 weeks, I hope to be back and saying that we passed Smokeout Act in the state budget.
I love it. Perfect. All right. Stay with us. Today's Verdict has so much more coming up right after this. All right, well, that's all we have for today. I'd like to thank our guests for joining us, and of course, you, the viewers, for watching. If you have an issue or a topic you'd like to see on a future edition of Today's Verdict, feel free to email me at davidlesh@bronxnet.org. And until the next time, know your issues, reach your verdict. I'll see you in 2 weeks.